Law of Contract, viva semester first LLB 3 year. Law of Contract, long answer question. All contracts are agreements, but all agreements are not contract. Answer: that's a classical principle from contract law, and it's absolutely correct. Let's see it clearly. Statement: all contracts are agreement, but all agreements are not contract. Meaning, every contract starts as agreement, but not every agreement qualifies to become a contract under the law. Step by step, we see the explanation. Agreement. An agreement is simply a promise or a set of promises forming consideration for each other. Formula: agreement is equal to offer plus acceptance. Example: A says to B, I will sell you my car for rupees 2 lakh. B says, I agree. There is an agreement. To contract. A contract is legally enforceable agreement. That means it can be enforced in a court of law. Formula: contract is equal to agreement plus legal enforceability. Example: A agrees sell to his car to B at rupees 2 lakh. They both sign a proper sales contract. This is a contract because it is legally binding. Why all agreements are not contract? Not every agreement has legal enforceability. Some agreements are social or moral in nature, not recognized by law. Example: B invites to A to dinner. A invites to B to dinner, then B is accepts. If B doesn't show up, A cannot sue him. It's a social agreement, not a contract. Legal reference: Indian Contract Act 1872. Section 2E. Every promise and every set of promises forming the consideration for each other is an agreement. Section 2H. Agreement enforceable by law of contract. In short, concept, definition, legally enforceable. Example. Concept: agreement, definition, offer plus acceptance, legal enforceability, not always, and example is promise to meet a friend. Contract: agreement plus legal obligation, legally enforceable, yes, and example is employment agreement. Write a short note on person of sound mind. Short note on person of sound mind. According to Section 12 of the Indian Contract Act 1872, a person is said to be of sound mind for the purpose of making a contract if at the time of making it he is capable of understanding it and forming a rational judgment as to its effect upon his interests. A person who is usually of sound mind but occasionally of unsound mind may make a contract when he is of sound mind. Conversely, a person who is usually of unsound mind but occasionally of sound mind can only make a contract during those interval of sanity. Example: person suffering from the mental illness cannot make a valid contract while his mind is unsound. A drunk or intoxicated person cannot contract when he is incapable of understanding the nature of the agreement. Thus, soundness of mind of the time of contract is essential to ensure that consent is free and valid under the law.